everyone and welcome back to the channel. My name is SHOILY and I'm working as a legal intern at LEXIS and Company. The topic for today's video is Article 39A of the Indian Constitution. What do we understand by the word socialism? Socialism in India is not understood in the Russian context where all resources are owned by the state and the state secures the welfare of all. Socialism, as envisioned in the Indian Constitution, aims at elimination of inequality in income, status, and standards of life. In many decisions, courts have interpreted socialism to mean a kind of social democracy which comes closer to the conception of a social welfare state as seen in the constitutions of France and Germany. The Constitution itself, however, does not define the term, but merely implies the above meaning through the rest of its provisions. Article 39 lays down 6 directive principles. Some of these are to ensure means of equal livelihood to men and women, ownership and control of resources be distributed to serve the interests of the people, there is no concentration of wealth, there is equal pay for equal work of women and men, etc. Article 39A, inserted by the Constitution in the 42nd Amendment Act of 1976, imposes a mandate on the state to provide equal justice and free legal aid. The article implies that free legal service is inalienable from the requirements of reasonable, fair, and just, as without it people would suffer economic disabilities, which cannot be a ground for someone not getting access to justice. This should be held to be implicit in Article 21, that is the fundamental right to life and personal liberty of individuals. In pursuance of Article 39A, the Parliament enacted the Legal Services Authorities Act 1987. The Act was enacted to constitute legal services authorities for providing free and competent legal services to the weaker sections of the society, to ensure that opportunities for securing justice was not denied to any citizen by reason of economic or other disabilities, and to organize lok adalats to ensure that the operation of a legal system promoted justice on the basis of equal opportunity. However, a major drawback in the existing scheme of organization of the Lok Adalats under that Act is that the system of Lok Adalats is mainly based on compromise or settlement between the parties. If the parties do not arrive at any compromise or settlement, the case is either returned to the court of law or the parties are advised to seek remedy in a court of law. This causes unnecessary delay in the dispensation of justice. It was proposed to amend the Legal Services Authorities Act of 1987 to set up a permanent Lok Sabha Adalats for providing compulsory pre-litigative mechanism for amendment was implemented for conciliation and settlement cases relating to public utility services. This amendment was implemented at a later date. It sought to do away with the problems mentioned above. However, though the law now provided implementation was lacking a large extent. Justice Krishna Iyer criticized the Act, saying that at times such adalats solved disputes not by relying on established legal principles, but with aims like ending feuds, securing peace to the family, etc. Although these goals are to be kept in mind such goals are only peripheral and not cardinal. They do not deal with core issues. Thank you. Please like, share and subscribe to the channel.